Can a felony be reduced to a misdemeanor? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. So a felony, being a much more serious charge, sounds like it couldn't be just reduced to a misdemeanor, but you're saying possibly it can?
Yes, we get this to happen all the time. Now, I can't say it happens, in all felony cases, but we are really able to get this to happen in quite a few cases. And so there's generally 3 different areas that we have to work on in order to get this to happen.
Okay, so what is the first one of those?
Well, a lot of times, unfortunately, prosecutors will overcharge a case. That is, they will say this conduct was so egregious that it amounts to a felony, when really you look at the evidence and they can't quite get that far. So say, for instance, if they're accusing somebody of a felony theft, that is a theft involving more than $1,000. Maybe they can only get to $800. And so in their, playing with numbers, maybe they've gotten it to over 1,000, but when you look at the other side of the coin, so to speak, they're going to have a hard time proving that. And so when it's a close call like that, you know that the prosecutor overcharged and we can probably get them to come down to a misdemeanor. So that's one instance.
So I was remembering a case that you and I worked on a couple of years ago where there was an accusation by the alleged victim of strangulation that turned out, which would have been a very serious charge, which turned out to be overcharging. What was the story of that again?
Sure. So with that particular case, there were lots of things wrong with that case, and we did get a very good result for that client. But unfortunately, he had to pay us money and he had to sit in jail. But in that particular case, what was reported was conduct that would amount to a battery if it were true. And through the course of questioning the alleged victim, the law enforcement officer decided that it shouldn't just be a battery, it should be a felony strangulation. And so when you looked closely at how that officer came to that conclusion, for instance, the victim was saying that he pinned me to the couch. Well, yes, he did in fact pin her to the couch, and he admitted to that, but it was only after she was punching him and grabbed his phone and threw his phone and was continuing to assault him that he pinned her to the couch. And so, that would be a self-defense claim. But the officer continued to question her, noticed that she had some redness on her neck and her chest, and her ear was actually red, and he started asking her whether or not she had a hard time breathing. She said yes. I mean, she was upset during the fight, and perhaps she was losing her breath. But it wasn't because of the strangulation. Now, he was attributing the redness to my client must have grabbed her by the throat. And so, the way he questioned the victim, he concluded that the reason that she had the redness and she was having a hard time breathing was because he strangled her, not because he pinned her to the couch. And so in that particular case, it was overcharged and there was problems with the evidence. And so, we had to sort through that. That was a case that was headed to trial because of what my client said happened and what law enforcement charged him with. So there were at least those 2 parts at this point with that case.
Yeah, so that ended up, getting moved down from a felony charge, and he ended up getting not any prison time, isn't that right?
Yes. So he was on the line to be a habitual offender because he had 2 prior felonies, and so this would have been considered a habitual, and so he was looking at 20 years minimum in prison if he got convicted, so it was really high stakes. But we took it a step further, so we knew that there were problems just with how the witness was interviewed, but we knew there was a lot of police contact between the 2 prior to this incident, and so my investigator went and pulled all of the prior police reports and started combing through them. Now, not all of those reports ended up in charges. In fact, none of them did. But when he was combing through those reports, he came across an incident very similar to this one, where the officer overheard the alleged victim outside of the door as they were arguing. They had called him to their house, and he overheard the victim, who did not know he was listening, say, "When the police get here, I'm going to tell them you threw me down and grabbed me by the throat." And you could hear my client saying, "Yeah, but I did not do that." And her response was, "Good luck proving that." And so we had her, dead to rights, fabricating a strangulation, telling the boyfriend, "I'm going to report that you strangled me." And then we have this circumstance where she flat out, called for an assault and embellished her story after she was questioned, saying that she was strangled. And so we took this evidence from our own investigation to the prosecutor. Now, the prosecutor wasn't necessarily aware of this. And because of that problem, we were able to reduce the charges from a felony, in which he was going to do 20 years in prison if he was convicted, to a misdemeanor where he would get credit for time served. It was a breach of peace. He just had to admit that there was a loud argument and that he used profane language. And that particular result was really outstanding. But that's where we went from a felony to a misdemeanor.
Great story of that. That really, I remember that outcome being so satisfying for everybody. And it's actually a really good example of how your firm is more than just you. You're the head of it, but you have this whole team, this investigative team, and none of this would have been uncovered without, all of the team paying such close attention. So if someone, really needs a service like that, how do they get in touch with you?
Sure. We'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.